Well, welcome everyone to Legal Futures webinar entitled Where Are We Now with the Test for Mental Capacity in Will Making, presented by me, Jill Steele of Law Skills Limited. For those of you following the TV series Inheritance on Channel 5, you'll appreciate the artistic license of the aftermath of someone dying in suspicious circumstances, leaving a deathbed will excluding all his children. The gentleman in the film was potentially lacking testamentary capacity, and there may even have been coercion too. Quite often, we are pleading these in the alternative when cases come to court. As all practitioners know, these issues have dominated decisions in court cases on wills for some time. More recently, there has been a discussion about whether the Banks and Goodfellow test had been overtaken by the test for capacity in the Mental Capacity Act of 2005, and whether or not these tests were the same and produced the same result. So therefore, it's timely for me to aim in this session to examine the concepts of mental capacity under both the common law and the Mental Capacity Act of 2005. With the help of some recent cases to establish the current position. Those of you listening will be able to use the relevant tools in the assessment of mental capacity when you're making a will for a client. Now then, I have divided this webinar into 5 sections, so we'll have a good deep dive into the test for capacity under Banks and Goodfellow, that 19th century case that we all love and know. And then we'll have a look at the wording of the Mental Capacity Act 2005 to make a comparison. There are some cases which have explored the differences or similarities between the two, so we'll have a look at those before examining in some detail the most recent case, which is Baker and Hewston. After that, I'll mention a few pointers before finishing on how to approach all of this. Okay, so to focus on the slides, I'm going to switch off the webcam and we'll just get cracking with the familiar test from Banks and Goodfellow.